Lordship, I beg to mention item number 4 with consent of other side, Lordship. After 1 week or next Monday, Lordship,
You were for?
I'm on behalf of T.S. Hazarika, respondent number 8182.
Respondent number 8.
Yes. Yes, Lordship. 818283.
Mr. Your good name?
K. Islam.
Learned counsel appearing on behalf of Mr. T.H. Hazarika, learned. Conducting counsel for the respondent number 8182, 83, 84, 85, 86. No, 8788. With consent from the other side, press for listing the matter after?
After 1 week, Lordship.
After 1 week. Bear allowed. This is a list the matter after 1 week.
May I please, Your Lordship, as per the last order, the bank was supposed to file affidavit. He has informed me he is filing it today. So let this matter be, let him file it today, and after that it may be fixed on the next week. It's a very small matter regarding. Last order dated 7/1/26.
You are on behalf of Canara Bank.
Yes, 1, 2, and 3.
Okay. Heard Mr. RZ Das, learned counsel for the petitioner, and also heard Mr. Sarma, learned standing counsel for the respondent number 1, 2, and 3.
Yes, Your Lord.
1, 2, and 3. Mr. Sarma submits that during the course of the day, he will be filing his counter affidavit. Then the learned counsel for the petitioner press for listing the matter on
10th or 12th, any date.
sorry,
90.
Deeply obliged. Deeply obliged.
I don't want it for order.
Wait, please, Your Worship.
Hmm.
My lord, in terms of order passed by this honorable court,
Hmm.
we have taken steps through paper publication in Sentinel on 17/1/2026,
Hmm.
and the Assam Tribune on 20/1/2026 for the appearance of respondent number 4.
Hmm.
And today is the date of appearance. None, possibly respondent number 4 hasn't appeared yet. So your lordship may fix a date so that they can appear.
Okay.
Because today is the date of appearance. We have filed our affidavit to that extent.
When?
That affidavit we have filed on, it is, sir? My lord, 2nd February of this.
Okay. Heard Mr. S. Dotto, learned senior counsel assisted by
K. Bora.
K. Bora, learned counsel for the petitioner, and Mr. Sarma for respondent number,
Respondent number 3, Your Lord.
respondent number 3. Mr. Dotto, learned counsel for the petitioner submits that the petitioner has published the notice. No, petitioner has served the notice upon the respondent number,
4 million.
respondent number 4 by substituted mode by paper publication, and to that effect an affidavit has already been filed before this court on 2nd of February 2026, enclosing the relevant papers, and he submits that the matter may be listed after 1 week,
Yes.
after 1 week, so that
Maybe after 2 weeks.
After
Let
2
them get
weeks.
sufficient time.
after 2 weeks, so that the respondent number so and so may enter appearance. Accordingly, taking note of the submission of learned counsel for both the parties, is provided that USSR lists the matter after 3 weeks.
Much obliged.
That is for hearing. Number? Number 3.
May I please, Your Lordship? It is a part-heard matter, Lordship.
Yes.
Yes, right. On last order also, it was stated that citation need to be given to the court or for essential certificate, Lordship, but my pardon, but we cannot get the citation, Lordship.
Yes.
So,
You have received any citation?
no, no.
No.
Lordship can kindly grant on the interest, Lordship. Only on the interest, Lordship, I would like to find the
Only interest.
interest part, Lordship.
So what was the interest granted by the trial court or the tribunal?
No, it was not granted, Lordship. On the we had page number 15, Lordship.
Hmm.
It was only stated that if the insurance company fails, then interest of 6% will be calculated. Lordship.
But it
Fails
was
to pay.
already paid, Lordship.
Only that interest was given.
The interest on the body paid to each other. কিন্তু কিমান পে কৰিছে ইন্স্যুৰেন্সে কিমান লৈছে তোমাৰ কিমান লৈছা মাত্ৰ কিমান লোৱা নাই but can I just go to the NPR
Yes, yes.
because
Timing is there, 60 days, until 60 days, there 6%.
Yes.
Then it's.
No, any other interest was given.
Okay. Next item.
Item number 5.
Yeah, please, Lordship. This is a challenge to an award passed by the labor court, my lord, Dibrugarh.
Hmm.
But prior to this, I am from the management and my friend Mrs. A. Bhattacharjee is appearing, my lord. Abha Bhattacharjee, my lord.
A Bhattacharjee.
Yes, my lord. She was here, but I think sometime we granted so that otherwise.
A Bhattacharjee. Folks.
Yes, my lord. She is here, my lord. She was here. She went to bring the brief.
Okay, after some time. After some time.
Or I may start, my lord. If otherwise.
Okay, you may start.
Before starting, my lord, may I place the list of this? But what when, my lord, the workman was appointed as their chief employee into 1995, my lord. And in 1995, with effect from 1/6 to 1995, my lord. And his job was to work as their chief employee, but for a few period of time, my lord, he was allowed to work as grade 2 employee. Therefore, my lord, he was again reverted back to the grade 3 employee. As because he was not paid the salary of grade 2 employee, so he raised a dispute, my lord, and accordingly a reference was made to the industrial dispute, my lord, industrial forum, my lord, industrial dispute act, under industrial dispute act, my lord, and it was registered as reference case number 17 of 2004, my lord. During the period, thereafter, my lord, on 6/6/2005, he was promoted to grade 2 employee, my lord. During the period when he was before from 2004 to 2005, certain anomalies regarding some financial anomalies was found against him, my lord.
Hmm.
Accordingly, a DP was initiated, my lord, and he was found to be guilty, my lord. And accordingly, one decision was taken, my lord, that he should be terminated, dismissed from his service. But as because the reference case 17 of 2004 was pending, a petition under 33(2)(b) was to be filed, my lord. Accordingly, their petition was filed before the tribunal by the management. That was registered as 1 of 2006. In the meantime, my lord, that in the Miss case 1 of 2006, my lord, evidences of management side was taken, my lord, recorded, my lord. However, the witnesses of the workman side was yet to be taken, my lord, recorded, my lord. In the meantime, the reference case was disposed of, holding that as because it is a hospital, so hospital does not come under the purview of Industrial Dispute Act under 2J of under section 2J of the Industrial Dispute Act. So that reference was dismissed. A word was passed that this reference will be dismissed. No reference is to be addressed by the tribunal. Accordingly, my lord, thereafter, my lord, the workmen informed the tribunal that they will prefer an application under 226 in the before this honorable court, my lord. Taking note of that, in Miss case 1 of 2006, the honorable tribunal allowed them two occasions to place any order, if any they get from this court, my lord, but that was not placed. Accordingly, in 2007, my lord, that Miss case was dismissed, my lord, saying that as because the main reference case was disposed of, saying that as it is not a dispute, the Industrial Dispute Court cannot address that issue because the hospital does not come under the purview of Industrial Dispute Act. So that Miss case has no role to play, my lord, because no permission is required. By holding that, the termination was, the dismissal order was not interfered with. Thereafter, the Reed court, the workmen approached this honorable court, my lord, and this honorable court, my lord, had decided that the hospital comes under the purview of Industrial Dispute Act. So the matter was remanded back to the Industrial Dispute Act, Industrial Court, Industrial Tribunal, my lord. Industrial Tribunal then decided that the difference of amount for grade 3 to grade 2 has to be paid to the workman. In the meantime, he was promoted to the post of grade 2 in 2005. So, my lord, they did not proceed. So, matter remains there. Now, as because that Miss case was disposed of, saying that it is the tribunal do not have any right to pass any order, as because it was not it does not come under the purview of Industrial Dispute Act. One Miss case filed by the workman, my lord, for restoration of the Miss case number 1 of 2006. That Miss case was again dismissed, saying that as because it is time barred, you have come very lately, and as it is decided already, so we will not interfere on that. After it was passed in 2014, thereafter in 2006, thereafter another reference was issued, was made, my lord, that is before this court, my lord, now, that 3 of 2016, 3 of 2016, my lord, and challenging the dismissal order. Challenging the dismissal order, my lord. And your lordship,
Second part has to go in.
Thereafter, my lord, this reference was made, my lord, and evidences were taken. Evidences were taken from both the sides, my lord. And finally, it was decided. Award was passed, my lord, on 23/2018. 23/2018, and according, being agreed, we have come to this court on by the city petition, my lord.
So what was the award passed by the labor court?
Labor, the the dismissal order was set aside, not set aside, my lord, I word no decision, no reasoning, without any reasoning. It was held that he is entitled for compensation. So, compensation at the of rupees 5 lakhs has to be paid. Without any reasoning why that dismissal order is bad, why the court is interfering with the dismissal order, no such reasoning was given. Lordship may find in the writ petition page number 107, the operative part, my lord. Paragraph number 25, my lord. May I read, my lord? Paragraph number 25. I have carefully sifted the evidence on record and considering the submission of the learned representative of both the sides and reliance of the decisions, I have come to consider it to the conclusion that the dismissal of the delinquent employee Nobin Borua from his service with effect from 16 to 2006 is not justified. So I decide the issue number 1 in favor of workman Nobin Borua and against the management Tata Referral Hospital and Research Center Sabua. Number 20, page 20, paragraph 25. Keeping view of all the facts and circumstances of the case, I am of the opinion that the compensation of rupees 5 lakhs only to the delinquent employee Nobin Borua would be a just relief in lieu of reinstatement. The compensation shall be paid to the delinquent employee Nobin Borua within 4 weeks, that is 1 month from the date of publication of this award, failing which the management shall have to pay interest at the rate of 6% per annum on the said amount. Accordingly, the issue number 2 is partly decided in favor of the delinquent employee Nobin Borua and partly against the management. Now, your lordship, if your lordship comes to page number 100, my lord. Page number 100, up to 16, my lord, all factual part and the submissions of both the parties were recorded. Paragraph number 16.
Mr. Hazarika, you say, you are Mr. Hazarika?
I am Manoj Mishra, MK Mishra, my lord.
Mishra,
Yes.
okay, sorry. You say, in lieu of reinstatement,
Yes,
this award was made in lieu of a reinstatement.
yes, my lord. For which I would like to place, my
So
lord, this,
can it be said that without any reason, the
my lord.
labor court has awarded the amount?
Yes, my lord, before that, my lord, before that, why that award was justified, that award was not justified, that opinion has to be rendered, my lord.
Hmm.
That opinion has not been rendered, my lord, here. Only up to paragraph number 16, all the discussions made on the basis of the submissions and the factual part placed before the tribunal, before the labor court, my lord.
Hmm.
Then in paragraph number 17, what it has been written, my lord, in page number 100, my lord, I have heard the argument of learned representative of both the sides. The learned representative, while arguing for on behalf of the workman, has submitted that the inquiry officer did not follow the principles of natural justice. The management also did not supply the list of their witnesses. to the workman before the inquiry was held, which is also violation of principles of natural justice. He has further submitted that the workman furnished the list of 4 witnesses, namely such and such and such. These are the submissions to management before the date of inquiry, but the management did not serve any notice to the said witness, and thus the workman was denied justice. The learned representative of the workman has further submitted that the workman Sri Navin Borua was dismissed from service with effect from 16 to 2006 during the pendency of the dispute reference 17 of 2004 pending before the Industrial Tribunal Dibrugarh without prior permission of the concerned court tribunal as per the provision 33(1)(b) of the Industrial Dispute Act, so the dismissal was completely illegal. This was the submission from the workman side. Now, on 18, my lord. On the other hand, learned representative, while appearing for and on behalf of the Tata Rafael Hospital, this is the management, has submitted that the domestic inquiry was held after following all formalities and natural justice. The workman Sri Navin Borua, in his evidence in the inquiry, submitted his guilt. The workman was found guilty and the management dismissed the workman Navin Borua from his service. Therefore, the management has not committed any illegality in dismissing the workman from his service. These are the recording of submissions made by both the parties. Now, the discussions from 19 to 24, my lord, only the judgments has been, which he relied upon, my lord, the court relied upon, my lord, as the consequence. What will be the consequence if he will be reinstated, or if he will not be reinstated, but compensation has to be paid or not? These are the discussions. But whether the court has decided why the termination was bad with some reasons, that was not mentioned, my lord. That was not, at least I have not found, my lord. Now, my lord, the question is his admission, my lord. Whether the issue was there, a sum of rupees 8,500 and odd, my lord, was misappropriated. Subsequently, in his representation, when notice was issued, in his representation, in reply to his notice, my lord, he submitted that 3,000 had already been paid, and he want to return back the another remaining 5,500 or something, my lord. That has to be, he wanted to refund back, my lord. That means he knew that this amount was with him. And taking note of that and the evidences laid by the parties, including himself, the inquiry officer in the domestic inquiry came to the finding that he had committed the wrong. And accordingly, opinion was expressed that he may be terminated. And accordingly, decision was taken on 16 to 2006 for his dismissal. As I have annexed all those documents, my lord. So thereafter, my lord, as because the 17th of 2004 industrial reference case was pending before the industrial dispute, industrial tribunal, my lord, petition under 33(2)(b) of Industrial Dispute Act had to be filed. And accordingly, it was intimated to him and a petition was filed. He appeared there. Evidences were laid down from the management side, but from the workman side, it had to be yet to be reduced. In the meantime, that reference case was decided that holding that as because it was a hospital, the management was dealing with the hospital and he was an employee of a hospital, and hospital does not come under the purview of Industrial Dispute Act. So this industrial dispute does not arise. The court did not want to interfere with the issue, my lord. Then that miscase was pending. When the miscase was listed before the tribunal, the workman intimated the court that this order was passed by the Industrial Dispute Act, the tribunal, and we will go to the High Court. the tribunal gave 2 times on 2 occasions. The order itself reflects, my lord. On 2 occasions, they did not turn to the court. No order from this court was placed. Thereafter, the tribunal in Miss Case 1 of 2006 decided that as because the original reference case was already decided, so, and that was not on merit and all, because it is not come under, it does not come under the purview of Industrial Dispute Act. So the permission from this court is not required. After that, this dispute came to the effect, this dispute was raised, madam. Now, my lord, I want to place one thing, my lord. The issue before the tribunal in reference case number 3 of 2016 was on 2 counts, whether the dismissal was bad, and if bad, what compensation or reinstatement, whether he is entitled for or not. We can find it at page number 79. Now, as the case proceeded, it was reflected, it was found that the domestic inquiry was held. And at no point of time, till the inquiry report was filed, though the workman appeared, adduced evidence from his side, no objection as regards the violation of natural justice was raised. The court, the tribunal, the labor court, my lord, did not take note of that, my lord.
No. Labor court has taken note of the submission made by the representative of the employee.
And as well as the management, my lord.
Yes.
And thereafter, he
So
went,
the representative of the employee has submitted before the person holding domestic inquiry
yes, my lord.
that it was in violation of the principle of natural justice.
That was at no point of time, my lord,
And
it
the
was,
list of witnesses was not furnished to him.
my lord, that was the submission, my lord.
Hmm.
That was the submission.
Hmm.
But the record
No.
says,
Whether the submission was made without any basis or without the record?
if your lordship permits me, I can read the entire judgment where it can be reflected that the inquiry, domestic inquiry was conducted duly and without any objection. He participated there. It was recorded in the judgment itself that he participated there. He adduced evidences. At no point of time, till the inquiry report was filed, he objected to any
No,
question, my lord.
you tell me whether the list of witnesses was furnished to him.
List of witnesses were not furnished to him, my
Not
lord, that is
furnished.
there.
Is it
But-
not violation of the
But the
principle of
list of
natural
witnesses
justice?
from his side also was not placed.
No, maybe.
But that point was not raised at the time of inquiry, my lord. Why he did not raise that question at the time of inquiry, my lord?
Maybe.
My lord, on that issue, my lord, I have some judgments, my lord.
Hmm. Hmm.
I have some judgments, my lord. If lordship permits me, one day I can place it.
No, okay, you place it. No problem. But the question is non-furnishing the list of witnesses to the delinquent employee is violation of the principle of natural justice?
My lord, my lord, the principle of natural justice is violated not from one side, my lord, from both sides, my lord. The witness has also to place the list of the witnesses also,
Hmm?
because he adduced evidences.
No, maybe he may adduce witness.
But that question will come later on. Before that, my lord, that whether the inquiry was duly conducted or not,
Hmm.
that has to be, and he raised any objection or not, that has to be looked into, my lord, by the tribunal,
Hmm.
by the labor court, my lord.
Hmm.
if all those things are raised, all objections were raised prior to the inquiry report was submitted, my lord, then that question may come. And domestic inquiry is not such a type of case, my lord, where as good as the civil cases, the list of cases has to be mandatorily placed, because he was asked whether you want to adduce any evidence. He said yes. Whether you have brought any witness, yes, I have 2 witnesses. Then call one by one, they appeared and they adduced their evidences. These are the things, my lord, in then domestic inquiry, my lord. And if that question was decided already,
So your contention is that you were not supposed to furnish the list of witnesses which you want to examine during the course of domestic inquiry.
no, that is not the thing.
Then,
When the notice was issued to the workman about the inquiry, he appeared before the inquiry officer.
no, now the core point is whether non-furnishing of the list of witnesses to the delinquent employee violates his right to natural justice or not.
That violates, but if that violates, my lord, if he, whether he raised any objection at the appropriate time, my lord, before the domestic, when the domestic inquiry was going on, that is not there.
No, whether you have provided any assistance to him during the course of domestic inquiry,
Yes.
you have
He was
provided.
cross-examined, he was cross-examined. He also cross-examined the work, management side, my lord. Both the parties were examined and cross-examined, my lord. Management side adduced 2 evidences, and that was cross-examined by the workman. And the workman side adduced 2 evidences. It was also cross-examined by the management. At that time, no question as regards to non-furnishing of the list of witnesses and all these things were raised. Thereafter, my lord, the inquiry report was placed before him, my lord. Thereafter, notice, second so-cause notice was issued. At that time, he said that no natural justice, the natural justice, principle of natural justice was violated. And the second so-cause notice. Thereafter, my lord, the case was remaining there, waiting for the decision of Miss Case, my lord. Miss Case of 1 of 2006. But it was decided that it is not, it does not come under the purview. So it is dismissed. And if he had any objection to that dismissal order, why he waited till 2016? Why he did not come at that time after 2006 or 2007? That order was passed by in the Miss Case in 2007. In 2000.
No. Is there any statutory bar in raising such points in a later stage?
My lord, the judgment says like that, my lord.
If what is those
I will
judgments
I
will
will
say?
place, my lord. I will place, my lord.
Say,
I could not bring today because I was under impression that 2 hearings are there and 1 reference is there, so it may take some time. So I did not bring those judgments, my lord, but those are there. And secondly, the decision, as I have read out, my lord, as it has come from this court, my lord, those observations, for the time being, for the argument's sake, I am admitting that natural justice has been violated for the time being. But not admitting, but I am just, for the argument's sake, I am. Whether that finding is there, whether that observation is there from the labor court, nothing, no discussion on that point. Without discussion, only merely on the basis after recording the submissions of both the sides, whether court can come. It is a court, my lord, it is a labor court, my lord, it is a court where only say that he is supposed to be reinstated, or if not reinstated, then compensation has to be paid. Some decision has to be, some reasoning must be there, my lord. Why? All right, I may have violated the natural justice, principle of natural justice for the time being.
Hmm.
But that has to be, so in that case, my lord, if lordship takes up the matter in the next week on any day, I may place
No,
the
today,
decision of-
today you complete your argument. You submit your decision later on.
my lord.
You complete your argument.
Then your lordship may kindly come.
Hmm.
May I read the judgments in the from, may I read the judgments, my lord?
Which judgment?
The award, my lord,
Hmm.
or the documents I have annexed, my lord.
Hmm.
From there also it will be clear, my lord.
Hmm.
Lordship may kindly come. To page number 65, my lord. Here, this is an order passed in case number 1 of 2006 by the Industrial Tribunal, my lord.
Hmm.
May I read, my lord? This case has arisen out of an application dated 16/2/2006 made by the Referral Hospital and Research Center Tata Tea Limited, Sabua, 65. District Dibrugarh, hereinafter called the applicant, stating therein that the opposite party, Sri Navin Borua, an OPD clerk under the applicant was served with the charge sheet for short deposit of amounts collected by him, and after receiving his explanation, an enquiry was held. The applicant has further stated that on the basis of findings of the enquiry officer that Sri Navin Chandra Borua was guilty of the charges, and in absence of any extenuating or mitigating circumstances, the opposite party, Navin Borua, was dismissed from the employment with effect from 16/2/2006. The applicant has further stated that at the time of dismissal, the opposite party was offered 1 month's wage and other dues, and that the misconduct for which he has been dismissed is not connected with the industrial dispute pending before this tribunal, and so this application under section 32(2)(b) of Industrial Act 1947 is being made for approval of his dismissal. On receipt of the aforesaid application dated 16/2/2006, the Referral Hospital and Research Center Tata Tea Limited, Sabua, a case being case number 1 of 2006, was registered by the tribunal, and a notice was issued to the opposite party asking him to file his statement of objection. It may be mentioned here that at the time of filing aforesaid application, the industrial dispute being reference case number 17 of 2004 between the same parties was pending in this tribunal. The opposite party, Navin Borua, represented by his union, Assam Sah Karmachari Sangha, approached and filed a statement of objection stating inter alia that the domestic inquiry conducted by the applicant was defective, improper, and against the principles of natural justice, and that the workman expressed his readiness to deposit a sum of rupees 5580 to meet the short deposit, and also to give an undertaking that in spite of this, the applicant proceeded to hold the inquiry and dismissed him. The Assam Sah Karmachari Sangha submitted further that the application for approval be dismissed. As the case proceeded, a simultaneous hearing on the validity of domestic inquiry as well as merit was taken, and after the applicant had examined 2 witnesses, the case was fixed on 29/11/2006 for evidence of the opposite party. In the meantime, the dispute between the same parties, that is reference case number 17 of 2004, which was pending before the tribunal was disposed of by an award dated 13/10/2006, holding that the disposal hospital was not an industry and that the dispute between the parties, one of which is a hospital, is not an industrial dispute. That on 26/2/2007, the date of evidence of the opposite party filed a petition praying for staying this proceeding on the ground that the opposite party would file a writ petition against the award passed in reference number 17 of 2004. Accordingly, the opposite party was allowed till 26/4/2007, but on this date, the opposite party neither appeared nor produced any stay order. But still, the opposite party has given an opportunity to adduce its evidence till 22/5/2007. But on this date also, the opposite party remained absent without any step. Hence, by fixing another date, ex parte argument of the applicant was heard. In this regard, in his argument, the learned advocate for the applicant has submitted that the applicant was able to prove the validity of domestic inquiry and the misconduct on merit. Also, that there is no victimization, that conditions of section 33(2)(b) of the Industrial Dispute Act have complied with while dismissing the opposite party, and that although hospital is not an industry, the application under 33(2)(b) of Industrial Dispute Act has been filed by the applicant by taking abundant caution. Since one of the parties of this, in this case is hospital, I shall first deal with the law point. Section 2J of the Industrial Dispute Act 1947 as amended in 1982 defines industry, which does not include hospital and the dispensaries in it. The appropriate making the requisite of making an application by an employer under section 33(2)(b) of the Industrial Dispute Act is pendency of the proceeding in respect of an Industrial Dispute Act. At the time of filing the application by Raphael Hospital, a reference as stated above was pending before the tribunal, but dispute referred in the reference case number 17 of 2017 between the same parties was held to be not an industrial dispute on the ground that the hospital is not an industry. Therefore, this petition of the applicant seeking the approval of dismissal of its workmen does not lie, and consequently, this tribunal has no jurisdiction either to grant or refuse approval of dismissal under section 33(2)(b) of the Industrial Dispute Act 1947. In view of this, I do not enter into the merit of the application. The application dated 16/2/2000 filed by the applicant stands disposed of accordingly. And thereafter, my lord,
Here, my lord, the award under salary, the award dated 2018, my lord. This order is under salary. Your lordship will examine this award, my lord, whether it is rightly passed or not. And other side is confusing everything.
I am not confusing, my lord. I am just placing the beginning of the case, my lord.
Your lordship will examine the award, my lord, in full, I guess.
Thereafter, my lord, miscase filed by the workman, my lord. Your lordship may find the order, my lord, at page 76, my lord.
Yes,
By this order, I am going to dispose of the pending petition filed by the petitioner workman Nobin Borua for restoration of case number 1 of 2006 by setting aside the dismissal. The petitioner has stated that during the pendency of the reference number 17 of 2004, the management has filed a petition under section 33(2)(b). My lord, I am pausing for a moment, my lord. their objection before the tribunal, before the labor court in 3 of 2016, my lord, was that petition under 33(2)(b) or 2(1) so 33(1)(b) had to be filed, my lord. That was not filed and no permission was taken, my lord. Now it repeatedly said that the application has been filed. So why I am reading this petition, my lord? I am not confusing, my lord. I am repeating why, because petition was already filed before the tribunal because the case was pending and the issue was raised in 2006 itself. The management had filed the petition under section 33(2)(b) of the Industrial Dispute Act for approval of the dismissal order of the workman, and the case was proceeded as usual and already recorded the evidence of management side, and the date was fixed for evidence of workmen, but the case was abruptly stopped by way of passing a non-effective order on 12/6/2007, which adversely affected the serious prejudice the workman for not fault of his own. While the main case, reference case number 17 of 2004, was taken up by the Honorable High Court on a writ petition filed by the Sangha, the workman was forced to abide by the order of dismissal, much to the charge in and discomfort not only to himself but to his entire family, and prayed to restore the case to file. In response to notice issued to the management has submitted the written statement. The management has submitted that the tribunal has dismissed the case on 12/6/2007, but no any appeal is filed by the workman against the said order. There is no order from the Honorable High Court for restoration of the case number 1 of 2006. While they approached the High Court, they did not mention about this case also, that this case was filed and this case some order was passed. Accordingly, if it would have been filed at that time, my lord, then court would have passed some order. As such, the petition for restoration is not maintainable and liable to be dismissed. I have heard the learned counsel for both the sides peruse the record. The management had filed the petition under section 33(2)(b) of Industrial Dispute Act 1947 for approval of the dismissal of the workman Nobin Borua, as the reference case number 17 of 2004 was pending before this tribunal. Said reference was disposed of void award dated 13/6/2006 and void order dated 12/6/2007. The case of 1 of 2006 also dismissed for want of the jurisdiction of the tribunal. The award dated 13/6/2006 passed in the reference case number 17 of 2004 was set aside and quashed by the Honorable High Court on in WPC 22372 of 2007 void order judgment and order dated 1/9/2009. But thereafter, at the belated stage of on 1/3/2013, the workman has filed the petition for restoration of case number 1 of 2006. As the main reference case number 17 of 2004 is disposed of today, and no longer pending for disposal, as such, the question of approval also does not arise. So under such situation, the missed case is dismissed, no cost. As because it was within the knowledge of both the parties that this petition was filed for seeking permission, my lord, and some order was passed. I do not understand why this point was not made before this honorable court, while they appear challenge that award of past at the initial stage, my lord, saying that it does not come under the reference under the Industrial Dispute Act. But if it would have been filed, then this situation would not have come. That was my submission. That is my submission. Secondly, my lord, as I have read out, the evidence was already adduced at that time. And if I can go to the inquiry report, my lord, inquiry report also recorded that he adduced 2 witnesses and that was also examined, my lord. I may go to the inquiry report, my lord. Before the inquiry report, my lord, I may be allowed to read out page number 43, which is the first so-called reply to the first so-called notice, my lord, by the workman, my lord. That he had admitted that this 5,580 rupees he want to deposit, my lord. That is page number 43. 2005, my lord. Focus on, or at page number 42, the focus was there. At page number 43, the response to the focus is there, my lord. May I read, my lord? Page 42 is the first show cause, my lord, 29/5/2005, 2008, 29/5/2005, my lord. That is the show cause, my lord. And in reply to that, my lord, this 3/9/2005, this reply has been filed, my lord. May I read? Page number 43, my lord. Sir, please refer to your letter of show cause notice dated 29/8/2005 asking my explanation in respect to of show cause of short deposit and shortfall of against the receipt of bill amount advanced from the patients of the hospital. That, sir, my submissions are as below. And I am indeed deeply shocked and regretted for the anomaly of whatever amount is involved. Number one, that I would very frankly admit that the amount in respect of against the 7 receipts shown from 3/8/2005 to 5/8/2005 in the period of 1 year and the deposited amount against which happened to be the short deposit of rupees 5,580, not 8,580 as stated. This is an error of oversight. The error is also due to overfreight on whom I entrusted, who sometime happened to recite the receipt numbers and amounts received against it for me, and I was to put it on the chart for time economy. But saying so, I blamed nobody else. But to myself, which become a lesson for me. I promise, sir, not to indulge such happenings in future, especially in money matters. The non-excess amount in cash box is somewhat puzzling me, and I have to discover it. Therefore, sir, anomaly above is not my intentional at all, nor it is an intention to cause a loss to the company while promising the and assuring not to recur same incident. I do remember my correct handling of lakh of rupees in the past without least blame or blot throughout my past career. Of receiving and depositing correctly for some about crores of rupees during my past tenure of my service. Assessed make me confident, saying dearly and that I am very sincere and very serious in discharging my duties. Number two, that the amount 3,000 against the cash deposit numbers assensus for the period from 17 January 2005 to 7th of February 2005, as mentioned in paragraph 4 of our your notice, in fact, had already been deposited. The reconciliation of the deposited amount and the receipt in total when examined removed the doubt overcast. Number three, that I would not deny the availability of some instances of cash receipts having been deposited on the very next day of deposit. This is because and happened that some amount of bill or advance handed over to me after the due deposit time over. In such cases, I have no alternative but to keep it deferred for the next day to deposit. Very often, I also happen to accept receipt of such amount after the due time of deposit at the proposed personal request of my colleagues and senior staff. And I bet this is not be treated as irregularity. Under the circumstances, I hope the matter is clearly explained, having been admitted pre. Therefore, I now earnestly request you not to pursue it further, considering the matter purely as oversight and being happened it inadvertently and allowing me to deposit the amount of rupees 5,580 only, being it as inadvertent loss or incurred and unseen. Once again, I reassure that I will be allowing no such scope of recurring such happening in future. So he admitted that at least 5,580 rupees was with him, and it has to be deposited. Now, my lord, inquiry was conducted. And after that, my lord, page 48, the inquiry report, finding of the inquiry officer. 20th October 2005. Very first page, your lordship may see serial number 8, name of witnesses of management. 2 names are there. Serial number 2, name of witnesses of workmen. 2 names are there, my lord. Name of neutral observer is there. 2 names are there, my lord. So from this page itself shows that he adduced 2 witnesses. This is first submission, my lord. This has to be recorded, my lord. And neutral observer was there. If any objection would have been there, it would have placed at that time also. Now, I am reading the inquiry report, my lord. The names of witnesses of the management were furnished to the workmen.
No, Mr. Mishra, you see, this report was prepared after conducting the inquiry.
Yes, my lord.
So where is the document to show that you have furnished the list of witnesses to the delinquent person?
Lord, kindly read I am reading this line, my lord.
Hmm?
I am reading this line, my lord.
Which line?
This page number 48, first line, my lord.
Hmm.
The names of witnesses of management were
No, this
furnished
is
to
the
the
inquiry
workmen.
report.
Lordship?
This is the inquiry report.
Yes, my lord.
It was prepared after conducting the inquiry.
Yes, my lord.
But before conducting the inquiry, whether you have furnished the list, where is the document to show that?
But that is on the record, my lord. That may be on the record, my lord.
Hmm. Oh, the record is-
record of 2000. If Lordship permits me, I have not gone through the record. The record, I think it has been recorded because this shows the record is here.
Record of domestic inquiry.
Yes, I think all the records has been called for. I have to see, my lord. Because two preference cases were there, two proceedings were there. Record of miscase number 1 of 2006 is also there required.
No, whether you have produced the domestic inquiry report before the labor court?
At this point, my lord, I have to verify, my lord, because as per my instruction, it was produced, but to produce before this court, my lord, I have to verify it. Because I have been instructed that it was produced. But I am not, without going to the record, my lord, I cannot place it before this court, my lord. And it would have been filed in the miscase number 1 of 2006. The record.
Okay, then you go through the record
Yeah, I may be allowed to.
after some time then?
Then, my lord, on another day, my lord, I will go for the two records are there. It may take time. sir.
Another date.
Another date.
Yes, ma'am.
Okay.
It can be possible.
Heard Mr. Mishra, learned counsel for the petitioner, and Mr. Hazarika for?
He is with me, my lord.
Okay, he
He's
is
with
with
me.
you. And Madam
If
Bhattacharjee for the respondent number 1,
2, my lord. That's one number 2.
respondent number 2.
That's one number 1 is the government.
Heard in part, lays the matter on
On 24th.
24. my lord.
24.
I will go through the record now, my lord.
Okay, okay.
Standing item 3.
Lordship, I checked the record.
Hmm.
The payment was made on 10/5/2016, and earlier also, I think a payment was made, but interest was not paid,
Interest was not paid.
not paid. So
You were
Lordship,
ready
till
to pay
that
the,
date, Lordship,
you were ready to pay the interest.
if Lordship thing is, the judgment was, to fairly submit Lordship, in the judgment it was mentioned that if it is not paid within 60 days,
Okay, you have made payment within 60 days.
no. That
Okay,
is what I'm fairly submitting, Lordship.
okay.
It was not, I should inform the court. Now the court and Lordship can decide the,
No,
the-
are you not supposed to make payment of the interest from the date of filing of the claim application, claim petition?
interest.
Yes,
Usually like that only, Lordship.
yes.
Usually,
Given by the tribunal also.
it is, usually it is like that. In this case, it was not given. It was given, conditional interest was given.
Mm.
That if it is not paid 60,
Mm.
within 60 days, then 6% interest. If Lordship wishes, Lordship can interfere with that, because in general, it is from the date of filing of the claim petition till the payment is made.
Mm.
So Lordship, here the payment was made on 10/3/2016. So 6% interest is at that point, Lordship, from the date of filing of the claim petition.
10/3/2016, you have paid the
And that
amount.
earlier,
at the-
I think earlier amount was 60,000 was paid, and on that day, the final amount was paid.
Mm.
So even if interest Lordship, interest will be that date Lordship, when the payment was made. From the date of filing. Which is usually done Lordship in other cases.
From the date of filing till 10/3/2016.
Yes, Lordship.
Okay.
Otherwise, there is no merit in the other grounds Lordship. As he.
No, he has already abandoned that.
Pardon, clear.
Okay, we will pass the order. Okay.
90th yet. I'm correspondent.
Okay.
Any of them.
Much of.
Item number 6.
Lordship, my senior is lagging in another court. Kindly pass the matter for time being.
Okay.
Can Lordship may kindly adjourn the matter, Lordship.
Why?
कोई बात नहीं, मालिक है।
Senior going.
Okay, Lordship, आपके साथ।
Item number 7.
My senior is coming. Is coming.
Who is your senior?
B Guswam, for listing committee.
Okay. Let him start.
Lodge.
Okay, on a small issue is that lordship, some land of these petitioners were acquired lordship.
Pardon?
Some land was acquired lordship from the tea garden of this petitioner
Hmm.
for the purpose of lordship constructing 4-lane lining road lordship. And accordingly lordship, formalities were lordship followed. And after following all these formalities lordship, we did not raise any objection at the time because the land was acquired for the public purposes lordship.
Hmm.
So we didn't have any objection. So accordingly lordship, the authorities, after examining all these lordship parts, notice was issued to this petitioner, stating that lordship will have the notice at page 32.
Hmm.
So just I'm reading 32 lordship. It was done as Dewan Tea Garden, which is also a group of tea garden, and one part is this petitioner. Regarding lordship land, it was the compensation amount was shown in the lordship right fifth column. 1,56,49,381, and Zirat value was shown lordship 2,40,59,010
Hmm.
rupees. So on the basis of this document, lordship, we were asked to provide all those lordship documents regarding our account and all, and we have provided all those things. In the meantime, lordship, after submitting all those, lordship, we were expecting to have our compensation, but in the month of December, lordship, we have received the first compensation. That is a Zirat amount of 2,40 lakhs. The Zirat amount we have received.
Hmm.
Then, lordship, in 3rd of March 2025, we have received another amount of rupees 1,30 lakhs, 55,718 rupees. Out of lordship, total land value shown in this notification, 1,56 lakhs 49,381. Now the balance is lordship yet to be received by this petitioner. That is amount to rupees lordship 25 lakhs 99,000 lordship. So on
But this amount has not been
not been paid.
paid to you.
Yes. Now
Okay,
the
this is
Friday-
your payer.
Yes, this is a basic payer lordship. So now lordship, they have filed an affidavit in opposition lordship, when they are quite silent lordship regarding our grievance. They have no were mentioned regarding this notification or this letter lordship, that page 32. And annex some document lordship which was issued subsequently.
Where is the award?
Award is also not provided to us lordship. And in this petition also our priority is to award, to provide a copy of the award lordship and all. And they have also not annexed the award copy in the affidavit in opposition. Lordship will have their affidavit in opposition at page 45. This is only a sanction order lordship. Page 45 is a sanction order. It is pertains to lordship the Zirat value. And the page lordship got page 45. This is
Mr.
running.
Goswami? Where is the award?
But big funds nowadays is, I think, not there in the petition, for the petition matter. Only if it once is to release the amount. Lying in the office of the responsible for. if he approach the authority, the authority is to make good money. But in any case, according to the file, we find number, the amount payable to the petitioner's member, that has been paid. So if he is aggrieved in any manner, my lord, he can certainly, is at liberty to approach the appropriate authority under the act, my lord.
Who is the appropriate authority under the act?
Arbitrator, my lord.
Arbitrator.
No, no, Lordship. That is not correct.
And other, I think. 5G, Z5 is also.
That part is different issue, Lordship.
National Highway 9. Out of Highway 9. Out of. National Highway 9.
It is 36, 3G, Lordship, 3G clause 5. That part is different, Lordship. Section 3G, section 5. That part is different, Lordship.
Now, out of clause of something. It Highway 9. Out of Highway is not.
56, 1956.
No. Out of provision is supposed to go an appropriate.
Okay, it is. It is. Subsection 5.
Ah,
Said it.
20 now will be said.
মই কৈছো কি আমাৰ গিভেন্স টো বেলেগ মোৰ কথা সেইটো বেলেগ। That is the chip, even after passing our page number 32. If we are not satisfied with the award and mentioned 32, then we have the liberty to approach the arbitrator. So for the time being, our grievance in this petition is the page 32. As per this notification, this letter issued by themselves, Lordship, we are supposed to receive this amount, but not yet received it. And for that enhancement, Lordship, it has. Not this,
Nothing is really pending. my lord.
they have not given any
That is
statement.
that is the contention of the petition, my lord. He does not have any kind of grievance with regard to award, my lord. Only thing, according to him, certain amount is yet to be paid to him. And in our agreement, we have clarified, my lord. Nothing has been kept pending, my lord, for payment.
So, here in page number 32, the total amount is 3 crore 97 lakhs,
Yes.
8,391 rupees.
Lordship.
And out of this amount,
That is not our, that is department also. letter, Lordship.
Subject to correction, my lord, subject to correction, maybe certain provision is there for deduction from the award amount. Because the, huh? I think that part he has not pointed out, my lord.
If there is such notification also for deducting our,
There is nothing to hide, my lord. It's a public, my lord. Why public authority will go hiding all these things, my lord?
Lordship, our prayer number 5.
3 deduct award is 2 crore 40 lakhs. Then 1 crore 30 lakhs, 55,000.
Lordship, kindly have our page number 15, prayer number 5.
And we cannot go money beyond what is said by the.
so
Award and the authority.
Mr. Goswami, the authority has started acquisition proceeding
My lord.
and also passed an award.
Right.
Whether those documents are not necessary to decide this present petition?
If in an appropriate case, certainly lordship. My lord, that power is always with your lordship, my lord. To look into this, but whether that grievance is raised in the writ petition.
That grievance is always there in the petition, Lordship. In prayer 5, Lordship, they have not yet provided a copy of the award. And even in their,
We have not done it, my lord, here.
nothing has been received by this petitioner, that is why we are
But
saying.
it cannot be accepted, my lord, nothing is
Lordship,
received. That is
what
not-
documents we have received, we have annexed.
Because
Then nothing in the writ petition, Lordship, we have a prayer to
before approaching this honorable, certainly it is at liberty to approach the appropriate authority in the parliament, my lord, to obtain all these things. And nothing can be done, my lord, without informing the petitioner. Every stage, petitioner is required to be informed by the authority, my lord. So it is not the case that authority is keeping mum, my lord. on the issues.
Hmm.
Ultimately, the thing, if he is disputed, certain provisions are there, deal it,
No, if you have deducted some of the amount,
Yes.
that is subject to, and I am not saying finally, as he is, saying all along, the certain amount is still pending to make payment, And
no,
in
no.
this regard
Uh,
also,
then you could have mentioned it in your affidavit.
Yes,
yes, no, according to our, that big, but it is also not that I am saying, that is the correct position. I doubt that if anything is pending, according to the petition, certain after this amount.
Hmm.
Let us do one thing. We adjourn the matter today. In the meantime, you produce the entire record
Lordship.
before
Lordship,
this court
yes.
on next day.
Lordship.
Heard Mr. Kolita, learned counsel for the petitioner, Mr. Goswami, learned additional lazy. Mr. Goswami, you are appearing in the capacity of additional lazy. Additional lazy for the respondent number.
I have proceeded representing 3, 4, and 5. 4, 5.
4 and 5. And Madam, you for 1 and 2, and you for 3. For 3. After hearing learned counsel for both the parties, perusal of the record is found to be necessary, and accordingly, Mr. Goswami, learned additional lazy, appearing for the respondent number 4 and 5, is directed to produce the entire record of acquisition proceeding, including the award before this court on suggested on
It is from,
Sir.
Kasla. 2 weeks after.
2 weeks.
2 weeks after, after 2 weeks, 26 Feb. All right.
Lordship.
May I have a copy of the order,
Okay, a copy of the order be furnished to Mr. Goswami during the course of the day.
Lordship. Obliged.
Item number 9, partner matter.
Yes, in.
This matter has been heard earlier also. The police record has also been called for in this case.
Which record?
The police record is okay, no?
Wait.
This record I have to Government was also made a party, Lordship, in this case. Domination was made a party as respondent number 5. Right, sir.
Is there a record price? So your plea is that accident was committed
By another motorcycle and my vehicle has been implanted, Lordship.
okay.
That is my case. But whatever the insurance company, appellant insurance company had examined the police officer,
Hmm.
Ratan Bhuya.
Hmm.
And as per him, he read out the GD entries, two
Hmm.
GD entries were exhibited, Lordship.
Hmm.
As per this, the police had gone to the spot and the two persons were lying there. One is the bicycle rider who died and the motorcycle rider who was injured. Both of them were sent to hospital and the motorcycle and the cycle both were seized and brought to the police station.
Hmm.
On the thereafter, Lordship, everything changed. Physically, a motor vehicle was lifted from the side and brought there. And but how about the vehicles? FIR was lost after 42 days. And giving another vehicle number, that is my vehicle number. How could this have happened? That switch, if that connection is established, how could a vehicle which was lying there be seized and replaced by another vehicle? This was the vehicle which is committed accident.
Hmm.
And Lordship, may
And,
refer to page 8
sir-
of the PS case, Lordship. There
No.
seems to be some kind
Mr.
of
Goswami.
Lordship discrepancies. In the police case record, Lordship, page 8, they gave a requisition on 8.
No, Mr. Goswami, whether you have cross-examined the IO
Yes, Lordship. The police,
and
he was
you have
here. He was the
confronted
IO.
him?
DW2 Inspector Ratan Bhuya, who was sent by the in charge of the police station for that I was not, he was the man who had written the GD entry.
Hmm.
He had gone to the spot,
Hmm.
brought the vehicle to the police station.
Hmm.
Now that part of the Lordship is a physical fact, hard fact, that cannot be whisked away. Now, how this can be replaced? There has to be some explanation in the charge sheet or so. This is, although this was seized, later we found it to be, that kind of explanation should have been there. No one can arbitrarily switch, just replace the number.
No. Whether the bicycle and the motorcycle was seized by the person concerned.
Brought from the spot by the police officer. This Ratan Bhuya.
No, whether it was seized.
Yes, Lordship.
Seizure
This
list
means
was-
they brought it to the Caesar list was prepared again showing the under vehicle number. How overnight this number could have changed, Lordship? There is some logical connection how this FIR GD got to be written in this manner. FIR could be accepted in that manner. FIR is filed 42 days giving this number. And everything seems to be, Lordship, a little backdated also because, Lordship, the records, there's overwriting in the records, Lordship. In the police case, page 8, there's an MBI requisition on the 9th. Because it's just clearly overwritten and written as 3 Lordship. And how could, GD is written on 7/7. MBI is given on 9/7. Caesar list on 9/7. Refers to the same police GD number, but with a different vehicle number. If you refer to the GD number, then the vehicle number should have been 4510. But in the MBI and GD Caesar list, it's mentioned as 349. Vehicle that has been brought as to the police station as per record is 4510. There's not even a semblance of some similarity, Lords. 4510 with distinct numbers, 0349. There could not have been a just misspelling, mistyping of one. Even the numbers, I think alphabets are also here. AS016. Even the numbers, alphabets, AS16A, AS19H. It just could not have been just one or two typographical mistakes. Some explanation need to be there, Lordship. A lot of fraudulent activities are going on, Lordship. I personally am aware of a lot of things where person has not died, but a case has been filed. It got even settled in MSCT, Lordship. And everything was removed from MSCT. Fortunately, a copy of this was sent to High Court, that settlement sheet. There's one case that person has been suspended. These kind of things are happening. In one case, someone died of a kidney disease and NDPS report was taken help of to even that claim was also settled. Now all these are in the FIR stage. So, I'm saying this just to show that lots of fraudulent activities take place in this area. It's turning out to be a profitable area for some scammers.
Okay. Yes, madam, do you have any explanation what happened about the motorcycle which was involved with the accident?
As DDNT that was not reflected, Lordship, said why in the FIR also, Lordship, they had filed in the lately, Lordship, that was no explanation, Lordship, in regard to the Lordship, the another motorcycle, Lordship.
So what is the number of the ZD entry which was recorded on the date of occurrence?
Lordship. Two records,
331 and 334.
331,
331 and 334.
675.
330, 334.
CD number? Mr. Goswami?
No, sir. GD number 330 and 334.
So the
Page 17 and 16, Lordship, of the page 16, 17.
So as per the ZD entry number 334 dated 7/7/25,
Yes, Lordship. 15, Lordship.
15,
Yes, 2015.
7/7/15, the number of the motorcycle was AS 16A 4510.
10.
And in the subsequent ZD entry dated in ZD entry number 861, the motorcycle which was no, in the Azahar it is mentioned the number of the motorcycle is AS19H
349.
0349.
49.
49. So when the vehicle was sent to the MVI for examination,
Yes, Lordship. It was. Lordship, may see page 8 of the PS case, Lordship. PS case record. Which is a requisition for MBI. PS case record here, page 8. It refers to ZD number 330, but the handwritten words under the heading description of vehicle, it appears to a case of it. There it is some kind of overwriting, erasing is there.
so madam, any explanation is available with you?
No, Lordship,
No explanation.
no explanation. And the present also,
But the only explanation available is that in the FIR,
yes,
the number is mentioned as
349.
49.
But what is again difficult to explain is how immediately after 7/7 on the date of accident, when they at night they brought it, next day or perhaps the next day, because the exhibit Caesar list is dated 9/7. It refers to the same GD entry, but a different vehicle number without correcting the GD entry. Or some explanation of the GD, why this GD entry number, vehicle number should have been this, not this. Straight away, there is erasing and overwriting also. Page 8 of the police PS case record. Probably it was done as an afterthought, some later, at a later point of time.
And Lordship, in earlier person, Lordship directed me to produce the names of the owners, Lordship. Vehicle number 16A4510.
You have produced the report.
Yes, that's right. That is there in the record.
Owner's name Zakaria
Yes,
Sampramari.
yes. Sir.
Sampramari.
Yeah.
But in this appeal, can we remand the matter to the tribunal to proceed against the owner of the
Yes, Lordship, that can,
motorcycle?
the person who 4510,
Yes.
that can be done, Lordship, because otherwise there has to be some logical connection between this.
No.
Against 4510,
Can we direct?
if it appears from the record that this is how it could have happened.
No, whether had it been a writ petition, then we would have no difficulties. But here this is MSCT appeal. We only examine the correctness or otherwise of the impugned judgment and award.
So, Lordship, it can be remanded for the purpose of examination of the EL, Lordship, to find out the truth, whether his vehicle, how his vehicle came to be related to this accident. For a limited purpose, it can be sent back to MSC, let them examine the EA, let all parties get a chance to examine the owner of the vehicle 4510. Then we'll come to a conclusion whether 4510 is involved or 349 was involved, without casting the final EA, Lordship. That this is the vehicle that was involved. Let that question be kept open and that person be sent notice and examined.
No, sitting in MSC appeal, can we
No.
direct in that way to the
Some matters are always remanded for a limited purpose of examination of a witness or taking some documents or getting evidence. This for a limited purpose, not
No,
throw away this,
Goswami,
set aside this
see,
judgment.
if we direct the tribunal to examine the owner of that motorcycle, he may not speak the truth there.
Yes, Master. You may not speak the truth here. That is also possible.
So what purpose will we serve by directing the tribunal to examine him?
It may come to a satisfactory, he may he must explain how his vehicle was found in the spot. How did he, there was some record in the police station, he went and took back delivery of that vehicle from the police station, that it was released to him. Police released to him some kind of.
No, he will make a simple statement that my vehicle was not involved. I don't know.
Yes,
How-
now we are again left to the question how it was found here.
So it may not serve the purpose. Can we direct the tribunal to proceed against the owner of that motorcycle in MSc appeal, perhaps we may not. Mr. Khan, you were the victim.
I am the victim of this way of that way,
Hmm.
but I am the victim.
Hmm.
Lordship, I have a submission, various submission on the issue raised by my friend.
Hmm.
My lord, one, an allegation has been brought of collusion that this is not a vehicle, another vehicle was in it, where implanted.
Hmm.
In their lordship, what was the liability or duty of the insurance company?
Hmm.
That has lordship, the Supreme Court, the Honorable Supreme Court has clearly explained in a judgment
Hmm.
that when such issue or complaint is raised,
Hmm.
it is the duty of the insurance company
Hmm.
to make a complaint before the higher authority, that is superintendent of police,
Hmm.
or he has to lordship challenge the FIR and charge sheet.
Hmm.
That admittedly he has not done. And
Hmm.
so far the GD entry is concerned,
Hmm.
those GD entries were not proved. Because the evidence of the DW1, that is the legal protocol of the insurance company, he has lordship aiding the
No,
evidence.
Mr. Khan, you see, both the GD entries are before this court.
Yes, sir.
And apparently there appears to be some fraudulent activities.
My lord, that,
Apparently.
my lord, that should be lordship established
Hmm.
through evidence by the lordship.
Yes, you see, the
Yes, then-
original DD book are
My
before
lord,
this court.
so far, criminal courts reports are concerned.
Hmm.
If you there prepared lordship, also there is a Supreme Court decision that the criminal court record cannot be denied in the MSCT case. And the evidence before the tribunal ought to be only considered for the determination of appropriate compensation. I have replied. Lordship, prepare written argument, citing those lordship citation lordship.
Hmm.
Your lordship consider this all this lordship point. I have answered with Honorable Supreme Court decision lordship.
Hmm.
Those record lordship, my submission lordship
Hmm.
cannot be relied in the MSC case.
Hmm.
This is the latest judgment of the Honorable Supreme Court in 2022 lordship judgment.
But when the fraudulent activities are apparent on the face of the record, can we shut our eyes?
My lord,
Hmm?
only on the presumption that the fraudulent activities was there.
Not presumption. The
And
record speaks
regarding-
otherwise.
Regarding changing of a vehicle number lordship,
Hmm?
the IO has explained on lordship on that very day of incident lordship, he has picked up that vehicle, and subsequent lordship after thorough investigation, it has found that another vehicle was lordship involved. Accordingly, that was sent for MPI report.
No, whether that was explained in the search sheet.
In Sashi, that is not there. But
Then-
they have not challenged that Sashi. FIR and Sashi, as for the Honorable Supreme Court verdict lordship,
Hmm.
they could have challenged it. I have given lordship the first judgment I have given in my written lordship.
Let us do one thing. You furnish a copy of your argument to him
I've got it today. I have received it today.
today. You go through it. You come prepared. And also come prepared as to whether we can direct the tribunal to proceed against that vehicle or not. Heard Mr. Goswami, learned counsel for the appellant. Mr. M. Khan, learned counsel for the respondent number 124.
I for what?
124. And Madam Burman for respondent number 5. Heard in part, list the matter for further hearing on. Mr. Goswami suggested that
For me, any date, I do not have any planned day, any date.
17
February.
17 February.
Maybe. Apni ko
I am for respondent number 1 and 2 lordship.
respondent number 1 and 2.
1 and 2.
Okay.
17 February.
Respondent number 1 and 2.
17 February.
Okay. We'll resume after.
Another fix coming.
every judgment. This is review petitions.
Hmm.
Our petition under Article 227 of Constitution of India was dismissed, holding that it is not maintainable. since-
Dismissed for?
Dismissed, holding that it is not maintainable.
Hmm.
Maintainable as an appeal lies against the order.
Hmm.
Now we filed this petition under Article 227, challenging two interlocutory orders passed in suit lawsuit.
Two interlocutory orders.
Interlocutory ones. What happened? A suit for specific purpose has been.
No, the question is whether any appeal lies against the said orders?
No lawsuit. No. What happened when there is a wrong mentioning of a provision, and that is what they are saying. It was a prayer. An order has been what order was passed for proceeding ex parte, as we failed to file written statement. That was after that a petition was filed praying for vacating that order and giving opportunity to file written statement. But while filing this petition, wrongly Order 9 Rule 13 CPC was mentioned. Prayer is correct, only wrong mentioning. And that is why we submitted decisions that wrong mentioning of a provision is not fatal if the court has jurisdiction to pass order. Now it was a petition praying for vacating the ex parte order. And Order 19 Rule 13 is for vacating, setting aside the ex parte decree. Suit is still pending. So Order 19 Rule 30 does not apply. It was a wrong mentioning. That was a mistake by the learned counsel before the trial court. And with that petition, he filed one application for condemnation of delay also, which was also not necessary. And that petition was rejected, saying that delay is not, reasons for delay is not sufficient. And thereafter, another petition was filed.
No, you have filed the application before the trial court mentioning it under order
9 Rule 13.
Order 9 Rule 13.
Lawsuit.
And that order is an appealable order.
My submission is, lawsuit may kindly page 8.
Now you are blaming the council.
No, what is the prayer lawsuit? That is the what prayer is. That prayer was in that petition. In the premises aforesaid, it is therefore prayed that Your Honor would be pleased to admit the present petition for condonation of below 60 days in preferring the application of Order 9 Rule 13, read with Section 151 of the Code of Civil Procedure for setting aside. Oh, sorry, it is a condonation. And in the main petition, it is therefore prayed that Your Honor may be pleased to vacate the ex parte order dated 1/11/2022. Date is also passed in TS number 113 of 2022, and further be pleased to allow the defendant to contest the suit by filing written statement. That is the prayer. And in the cause title, it is mentioned Order 9 Rule 13. This mentioning is wrong mentioning of the provision. But the prayer is correct. Honor learned court, trial court has the power to power and jurisdiction to decide this.
So you say this order was passed by this court on 8/11/2024.
Lawsuit.
And you have filed this application on
24/11 within 30 days.
within
30 days.
within 30 days.
On 20th day of November. we went.
Okay.
Now, under 4 and 9 Rule 13 to 11. Only thing, Lordship,
Hmm?
the order,
Hmm.
Lordship, may kind of page 85.
Hmm.
This is the order 1/11/2022.
Hmm.
This is the order by which
Hmm.
it was directed to proceed ex parte. The suit will proceed ex parte against the sole defendant without his written statement.
Hmm.
This is the order. This order was challenged, or for vacating this order, the petition was filed. The petition is the next page, Lordship.
Hmm.
In the cause title, Order 9, Rule 13 has been mentioned.
Hmm.
Order 9, Rule 13, but Order 19, Rule 30 applies to setting aside of ex parte decree. The order dated 1/11/2022 is not an ex parte decree.
Hmm.
So, in the prayer also, it is correct. Prayer portion, Lordship, page 88.
Hmm.
Prayer is, it is therefore prayed that Your Honor may be pleased to vacate the ex parte order dated 1/11/2022. That order in a year, and further be pleased to allow the defendant to contest the suit.
Hmm.
So, prayer was not for setting aside ex parte decree, nor there is any ex parte decree. Only this quoting of this provision
Hmm.
is not fatal, because wrong mentioning of provision is not fatal if the court has the jurisdiction to pass order. Prayer, court has to see what is the prayer. Now, that petition was rejected on the ground of delay, because as it was filed in Order 9, Rule 13, so Learned Counsel filed it after 62 days. So he's filed an application for condonation of delay. This is the first petition for vacating the order.
Hmm.
That is disposed because delay was not condoned. Delay was not condoned. It was dismissed. Thereafter, he filed another petition, now in correct provision, Order 9, Rule 7. It ought to have been, the first petition was supposed to be on Order 9, Rule 7.
Hmm.
Now, Order 9, Rule 13, Lordship, if I may read for a while, it says, setting aside the ex parte decree ex parte against defendants. In any case in which a decree is passed ex parte against the defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if he satisfies the court that the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to cost payment into court or otherwise as it thinks fit, and shall appoint a day or proceeding with the suit. My humble submission that this is not an application under Order 9, Rule 13, although it was wrongly mentioned in the cause title. And the Learned Trial Court has the jurisdiction to vacate the order dated 1/11/2022, by which it was directed to proceed ex parte. That is challenged before Lordship. And subsequent to that, the correct provision, Order 9, Rule 7, petition was also filed, and that was rejected mechanically, saying that the earlier petition was rejected, that is this petition, Order 9, Rule 13(1). So it was also rejected. That's why we have filed this petition under Article 227. Had there been any ex parte decree, an appeal would have been filed. The instant case service was not served upon the defendant. It was upon his attorney. Otherwise, order 9, rule 13 order is appealable. It is correct. But in our case, the facts, the situation is different. I am saying it is a wrong provision because the prayer is correct. And that is why I relied upon decisions showing that quoting of mentioning or non-mentioning of wrong provision or incorrect provision is not fatal if the court has the jurisdiction to decide.
Mr. Ghosh, what is your response?
My response is that, my lord, lordship has correctly passed the order because of the fact that earlier for setting aside of ex parte decree or order, here in this case, setting aside ex parte order was passed, or application was passed under order 9, rule 13. That has been decided by the trial court. Against that, there is a provision for appeal. They have not chosen for appeal. What they have done, they have filed another fresh application, order 9, rule 7. Earlier order attains finality. Then subsequent application has been filed. That application was rejected on the ground that since it has been already decided, so matter need not require to be adjudicated afresh. Apart from that, my lord, the court has also not jurisdiction while the matter has already been decided. The trial court. It is their, they have ought to have been filed an appeal. And this is the language, order 9, rule 7, as well as order 9, rule 13.
No, Mr. Ghosh, there is no dispute that the order 9, rule 13 is appealable order.
Yeah,
Yes.
Appealable order. He has also not been disputing it.
then
His contention is that the engaged counsel before the trial court has wrongly quoted the provision in the application.
that cannot be a ground for review.
Hmm.
Because why it cannot be a ground for review? The order 9, rule 13 application has been decided. Rightly, wrongly, whatever it is, it has decided. While it has been decided, without challenging that order, they file a fresh application before the landed trial court again, once again. When that application was rejected, that application was order 9, rule 7, then they have come with this.
Both the orders are challenged, lordship.
Please let him come.
Now they have come with the application 227. How can both the order can be challenged? Once they have accepted earlier order and they have filed a fresh application order 9, rule 7. Order 9, rule 7 application has been filed. Now, earlier application order 9, rule 13 has correctly filed. That is why I am showing the language of the order 9, rule 13. Can you see? Setting aside decree expert against defendant. In any case, in which a decree is passed expert against the defendant, he may apply to the court. That means he may apply to that court. by which the decree was passed for an order to set aside. And if he satisfied the court that someone was not duly served, here in this case, someone not regarding someone. On that day, he was prevented by sufficient cause from appearing when the suit was called on for hearing. The court shall make an order setting aside the decree as against him upon some term as the cost payment into court or otherwise at its fee, and shall appoint a day for proceeding with the suit. Provided that where a decree is of such nature that it cannot be set aside as against such defendant, only it may be set aside as against all or any of other defendants also, provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been necessity of service. Now kindly see order 9/7. What he is saying, that it ought to have been order 9/7. Procedure where defendant appears. Lordship got it? Here in this case, defendant did not appear. Defendant appears on the day of adjourned hearing. Adjourned hearing. And assign good cause for previous non-appearance. Where the court has adjourned the hearing for that suit ex parte and defendant at or before such hearing appears and assign good cause for his previous non-appearance, he may upon such term as the court direct as or otherwise be heard in answer to the suit as if he had appeared on the date fixed for his appearance. Now what order has been passed, kindly see by the trial court.
One, 2.
First order. And this point was argued before this honorable court while the matter has been decided by this honorable court. It is not that it was not argued, it was not taken into consideration. It was taken into consideration by this honorable court and passed the order since there is an alternative remedy. So this revision under 227 is not maintained. Then 227. This is the only ground. They can go for appeal against that order. And that appeal is not like before this honorable court, it will be like before the civil task. And since they have not preferred any appeal against the earlier order, that is why they filed this, tactfully this 227 petition. Because there was a 30 days question will become. That is why they have, without filing this appeal, they filed another application order 9/7. Then clubbing together, they have come before this honorable court. Now kindly see the 112 page. Parties are represented. Today is fixed for order of in which not this one.
This one, 24/5/2023.
Prior to that, before filing application, before the London Trial Court under order 9/13, what order has been passed by the London Trial Court?
Page 85. Page 85, Lordship. 1/11/2022.
Plaintiff side represented, defendant filed petition to adjourn for filing written statement upon the plaintiff objected. However, it appears from the case record that someone stood served on sole defendant on so and so. Defendant failed to file written statement till today. Defendant got sufficient opportunity since appearance on so and so. No written statement filed by the defendant. The reason shown is not convincing. Hence, considering all aspects here is rejected, suit will proceed ex parte against the sole defendant without his written statement. However, defendant is at liberty to participate in the hearing of all cases. So, WS was not filed. And when the WS was not filed, court has no option to pass the ex parte. Here in this case, he has not come up with this application that no, I may be allowed to give an opportunity to file WS. Here is the no WS. Lordship got it. So when WS was not filed, only what remedy is court is, if it proceed ex parte, only rider has been given that he can examine, cross-examine to me or participate with respect to that. He will not be allowed to even adduce evidence also. So under such circumstances, this honorable court has not committed any irregularity or illegality in passing the. So there is no error apparent on the face of the record. Because kindly 1/11/2002 order is very much clear that he has not participated in the proceeding.
But as was my application, first application after.
He is harping on application.
Yes, yes.
I am not saying what provision has been quoted, what is, from which order he has come. This order, order dated 1/11/2022 is the main main order against which he has come for ex parte. Suppose it ex parte vacated.
Yes.
Will he provided the opportunity to file WS? No.
Well, that is why we have come. That is the case, because we cannot directly challenge 1/11/2022 here. That's why that petition was filed with a wrong quoting of wrong provision, mentioning wrong provision. But prayer was correct. Prayer was correct. This is what he is not understanding. Prayer was correct. So therefore, it was essentially not a petition under Order 9 Rule 13 CPC, although it was quoted Order 9 Rule 13 7. Prayer was for vacating the order, not setting aside ex parte decree, because there is no ex parte decree. It was reacted to proceed ex parte or ex parte against me. So I come before the court and pray to vacate this order and allow me to give opportunity to file written statement. But wrongly mentioned the provision. Now he is saying it was my petition is this present petition or earlier petition 220 was not maintainable because it was an order against Order 9 Rule 13. Yes, made it complex. But
humble submission, this order is also, he can come up with the application under 227. He has not, this order attains finality, my lord. Because he has not filed WS, proceed ex parte.
This is
Court
what challenge
has no
before.
option. Court has no option. It will proceed ex parte.
Yes.
Because written statement is not on record.
No, that order is also challenged here.
Yeah, so everything
No,
was
this
challenged.
challenge, 1/11/2022.
1/11.
2022.
Post title, Lordship, paragraph, page page 29. Page 29. Post title.
No, that is challenged.
All three has been challenged here.
In the CRP,
CRP, yes.
that was challenged. That was challenged.
1/11/2022.
Yes. That was challenged.
Then 24/5/2023 and 14/3/2024.
So your contention is that the order dated 1/11/2022 is not a decree.
Not a decree.
It is an order to proceed ex parte
Ex parte.
against the
Defendant.
defendants.
So we filed an application praying for vacating the order. That is page 8, this application, Lordship. Page 86 application. For vacating the order and allowing me to file written statement. But in the cost title, wrong provision has been quoted. Order 9 Rule 13 CPC instead of Order 9 Rule 7. Along with an application for condoning delay. That was
But
rejected.
the question is whether the order dated 1/11/2022 is an interlocutory order or not.
Interlocutory order. Because suit is pending.
Now, kindly see, my lord, what application he has filed, order 9 rule 13, I forgot all these things. What has been decided in that case? That is the main, kindly see page 116. Directly.
Yes.
Second paragraph. Payable the case record of title number so it is found that on 12/7/2022, lordship got it. The defendant entered his appearance and filed one petition along with Kalatnama praying for time for WS, which was also allowed subject to law of limitation. That means for filing written statement was allowed. On next day, 18/8/2022, again defendant prayed for time to file written statement. Got it? Similarly, on 23/9/2022, also defendant by filing petition prayed for time to filing written statement, which also allowed subject to law of limitation, fixing the next date 1/11/22. However, on 1/11/22, against the defendant prayed for an adjournment for filing written statement upon which the plaintiff side has objected. Hence, this court perused the case record and found that someone served on so and so, but the defendant failed to file written statement till 1/11/2022, and that till so and so, defendant got sufficient time for filing written statement, but he did not do so, and hence the reason shown was found to be not convincing, and hence considering all aspect, prayer of the defendant was rejected, and same the suit proceed ex parte against sole defendant without written statement. Conduct. And 90 days, its period is, limitation period is 90 days. Let me finish it.
It's okay,
Period
but
of limitation 90 days. 90 days over. He is not filing. What court will do? The court, nothing, court has no option. It will proceed ex parte because written statement was not filed. Then on by this application, it's order 9 rule 13, whatever it is, he has not come up with this application that I am filing written statement, kindly accept the written statement. It is not the case. He has not come up with this such prayer. He has directly come up for setting aside an ex parte order without filing written statement. He ought to have been filed an application that yes, this is the reason I am filing the WS today. Kindly vacate the order and proceed the case. That was also not case. He has not come up with clean hand. Then, when this application was rejected, then again, kindly see, again another application has been filed. Order 9 rule 7. In that application also, he has not come up with the written statement. He has not come up with the written statement. What court will do, my lord?
No, that's all right.
Conduct of the parties is to be considered. And apart from that, when this application, one after another application is filing without filing written statement, how court will proceed, my lord?
I will explain this.
No, explanation key, even then, even.
It's a collusive
at
suit,
time
lordship, how they have filed
at
with my
time
attorney.
filing Civil division also, they have not come up with such prayer that yes, we are ready with the WS. Let me give one opportunity to file WS. Suppose set aside, ex parte degree set aside. Will they allow to file
Mr. Ghosh, you
WS?
see, in this CRP, we have not gone into the merit of the order.
Yeah.
We have only decided about the maintainability of that petition.
Exactly.
Yes, we have
Yes.
not gone into merit of the orders.
My humble submission, this honorable court has not committed any wrong or committed any considering the application as well as order has rightly passed, they may alternative remedy is there, so he may prefer anything. It is an appealable order. Admittedly, it is an appealable order.
Okay. Okay, we'll pass the order then.
Yes, my lord. My lord.
Only on lordship will pass on this. If lordship finds it is maintainable, then merit is also required.
No, now we are not on the merit of the order.
Okay.
Now we are to see whether this revision petition we can entertain or not.
Yes.
No, this review petition we can entertain or not.
In that case, lordship, I will be allowed to submit petition. Regarding review, whether it is. But what he is saying, it is not, he is also on mistake of facts. What I have earlier also I submitted decision, today also I have brought that wrong quoting of.
No, that
provision.
is well settled.
Yes.
That is well settled.
I have-
proposition.
I have
That is my
mistaken of
contention.
fact. I-
So therefore,
Submitted on record, I have submitted which he has filed.
therefore, lordship,
Beyond the record, I have.
therefore, lordship, if the prayer is correct, if it is not fatal, so this order was not, it is not an order against setting us, for setting aside expiry degree. So that is, no appeal does not lie. It is a wrong quoting. That is the main crux, lordship. If it is wrong quoting of provision and it is not fatal, court has the jurisdiction to entertain that petition. So appeal does not lie. It is an interlocutory order.
No, now we will only see whether there is any error apparent on the face of the record or not.
Yes.
That is what that is why I am submitted this decision, lordship. Lordship may kindly
2000
see.
my lord. Title suit 2022 till now no proceed. Our
It's not of-
stay like this.
If I may,
Neither can been cross-examined, nothing.
with my power of attorney, they collusively filed this lawsuit. In the plaint itself mentioned that payment has been made to the power of attorney holder. I am nowhere, I do not know anything. Even in the plaint also, they filed the suit, my name represented by power of attorney. Why? Notice was served upon this power of attorney holder. It's a collusive. Lordship, kindly see paragraph 88, 89, 88, 89. It says, lordship, order 47 rule 1 of the court provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of new and important piece of evidence or when there exists an error apparent on face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. I am not saying there is apparent error or something. There is sufficient reason, lordship. And sufficient reasons is apparent from the face of the application that prayer is for vacating the ex parte order and giving opportunity to file written statement. This application is page 85.
Whether they have filed any review against that?
He is unnecessary.
Mr. Ghosh, please.
He is filed
So
hardly-
therefore, there is a sufficient reason. Sufficient reason that this our article 227 petition is maintainable because no appeal lies against such prayer.
No, Mr. Purkar, so you tell me one thing. Against the order dated 1/11,
Yes.
2022,
22.
whether you have filed any application before the trial court
Yes.
enclosing the written statement?
No, that was not there. We filed petition for vacating the order and
No,
on merit it is their lordship. This is not there. It is not there. We only filed petition
no,
for
no.
vacating the expiry
You
order.
you are supposed to enclose the written statement with the application filed
In
by
an
me
ideal
before
case,
the.
yes. In an ideal case, is I can submit fairly, lordship.
No, no. not
In ideal case,
case.
yes.
Is it not the requirement of the law?
No, always not, lordship. If in ideal case, I will advise, if I say I will advise my client to submit the written statement along with an application for acceptance and vacating order. In that case, it was not done. In ideal case, it is, lordship.
No, no. Is it not the requirement of the law?
No, court can enlarge time, and under if the judgment, lordship order 8 rule 1 says 90 days. If it is not
No,
filed,
if that being so, is there any due diligence on your part?
as it was expiry order in the instant case, lordship, as it was, and it was ordered the suit should proceed expiry, it was not filed, but it should have been filed. I admit that it should have been filed.
It was not filed.
It was not filed, only for petition was filed for vacating the expiry order and giving further opportunity for filing written statement. And section 148 CPC, it is clear that it can be done. And if the
No,
court that
you
did
see, that power is discretionary.
discretionary,
How the court will exercise the discretion?
because lordship court did not pass any judgment, order 8 rule 10. Salem
That's all right.
Salem Advocates
Had
Bar-
your application been accompanied by the written statement, definitely the court would have considered.
It was not there, lordship.
Then-
It was not there. It was not there.
Then can it be said that the court has erred in exercising its discretion?
The court court rejected my petition that there is no sufficient reason for condoning delay, because everyone went on this
No,
putting
is
of
it
provision.
not the reason that your application should have been accompanied by the written statement?
I have submitted, lordship. In ideal case, yes, it is. It is. In ideal case, it is. I'm submitting fairly. In ideal case, it is.
Okay, we will pass the order.
Job life fees.
Ultimate.